Okay, good morning everyone and welcome to our online webinar on the topic of COVID-19, Labour Law for Businesses, Employers Part 2. In case you have missed Part 1, which screened last week, it is available on our website and you can view the whole webinar from there. So yeah, if you want to take a look at it, you can go to our website. So my name is Sarah Haffenden and I'm the Marketing Communications Manager at UKZN Extended Learning, also known as UEL. So in case you're unfamiliar with who we are the Continuing Education Unit of the University of KwaZulu-Natal, and we offer all the short courses on behalf of the university. So while we're offering these webinars as we are in full support and compliance with the directive of a national lockdown issued to address the COVID-19 pandemic, we are embracing the changes and are working on a number of projects aimed at providing free access to learning materials during this lockdown period. So one of the projects is our online learning webinars. So this learning webinar comes part of our Learning Lockdown Initiative, which is a 4-part series focusing on labour law issues relating to COVID-19. We also have already launched a series on the changing world and the fourth industrial revolution, which takes place every Thursday. The labour law takes place every Tuesday, with the exception of next week, Tuesday. We'll be giving a week break, and the next one will take place on the 5th of May. But please do take a look at our final slide at the end of the webinar for further details on all the upcoming webinars. Or you could also visit our website, www.ukznextendedlearning.com. I'd now like to introduce you to our guest speaker, Dr. Tamara Cohen. Tamara is a former Associate Professor of Labour Law in the School of Law at UKZN and currently an Honorary Research Fellow at UKZN. She is an experienced labour law trainer and facilitator, a panelist of Equitate Professional Employment Law Solutions, specialising in labour matters, an accredited commercial mediator, and an admitted attorney. She has co-authored various labour law texts, including Labour Law Through the Cases, Labour Relations Law, Trade Unions and the Law, Labour Law in Context, and Laws Against Strikes, Strikes in the Law, and Labour Law, amongst others. She has published many articles in the field of labour law in leading law journals and has presented conference papers both nationally and internationally. She has also facilitated many workshops on various aspects of labour law. So welcome, Tammy, and over to you.
Thank you. Good morning, everyone. I hope it's been a acceptable week for you under our extraordinary circumstances. Last week, I spent a lot of time talking about the TERS, that's the UIF Temporary Employee Relief Benefits Scheme. And I just wanted to give you a little bit of feedback on that, some developments over the last week before I get going with this week's topics, which I will take you through in a minute. But there's been a lot of actually negative feedback, despite my upbeat optimism last week about the amount of money, the 30 billion rand that has been set aside, and despite my reservations expressed about the UIF's capabilities of administering the scheme, I still was cautiously optimistic. Unfortunately, as I feared, there have been teething problems, and the Minister of Labour has communicated that the UIF will probably be unlikely to be able to meet all the expenses in light of the tens and tens of thousands of applications that have already been submitted. So despite the fact that the UIF in fact has money in its coffers of apparently 200 billion rand, I think the administrative overload might prove to be the undoing of the scheme that originally intended to make payments very quickly and very swiftly to offset the damages incurred by employees and not earning an income at all during this period. So what I'm going to focus on today, I'm not obviously going to repeat what I discussed last week, and that is available, as Sarah mentioned, on the website as a rerun. But what I would like to spend a little bit more time looking at is what about this obligation of employers to pay benefits, and this also includes bonuses. And this is a question that's been asked of me on several occasions. What do employers do now? There's annual benefits coming up or discretionary bonuses. Are they expected to pay that in addition to, and I did allude to this briefly last week, in addition to medical aid contributions or pension and provident fund contributions over this period? I also am going to look at what the requirements are for employees and employers to make a compensation for occupational injuries and diseases claim in terms of the Compensation Act. What are the procedural requirements and how easy that is going to be to comply with. I'm also going to talk briefly about leave. Can employees now be forced to take their annual leave during this lockdown? And is there, are employers obliged to their full pay during this annual leave? And also, can this then be extended to negative leave, eating into next year's leave and unpaid leave during this period? Another big issue, and I will spend quite a bit of time on this, is can employees be just converted over to short-term or a temporary layoff, which is part and parcel of retrenchment procedures in terms of the Labour Relations Act. And I'd like to address briefly what kinds of procedures apply in that situation, because it's not a simple act of just notifying employees that they are now officially on short-term. Then as far as essential services employees, and I know that the net of essential services is being broadened all the time, can they be forced to work? Does a refusal on their part to work constitute insubordination? And what should the disciplinary consequences be in that situation? And then the final thing that I'll be addressing is what are the obligations of all employers, certainly post-lockdown, when employees come back to work. What are their obligations from a health and safety perspective, and will they be liable if they do not meet? Will they be liable, in fact, in terms of the common law and delict, breach of their duty of care towards their employees if they do not comply with these health and safety considerations going forward? In terms of the obligation to pay benefits, and for those of you that were listening in last week, there is an element of repetition just to get to the main crux of this. But as I mentioned last week, the fact that employers are excused from paying any kind of remuneration if their business has closed down entirely, or part of the remuneration if their business has closed down partly, relates back to the common law principle of supervening impossibility of performance, which effectively is a contractual consideration arising out of the common law that if a contract is unable to be performed as a result of absolute impossibility, which in this COVID-19 scenario where businesses are closed down really does become absolute impossibility or absolute illegality in some senses. That, as I said, relates to the maxim of no work, no pay, and employers are excused from paying any remuneration over this time. But as I've said, I'm going to address what does this mean for as far as bonuses go, or does this excuse employers from paying discretionary bonuses at the end of the year, or does this affect the obligation to pay benefits in terms of medical aid contributions or pension or provident fund contributions? Now, in terms of benefits, the Labour Relations Act governs unfair conduct with regard to the provision of benefits in the unfair labour practice provision, which is section 186(2) of the Labour Relations Act. And an unfair labour practice perpetuated by an employer on an employee is actionable at the CCMA, and in fact can lead to compensation awarded by a commissioner in favour of an employee up to 12 months' salary. That is, if an employee is subjected to an unfair labour practice arising out of irrational or unfair conduct on the part of an employer. So employers that are withholding benefits need to make sure that the reason for withholding benefits is reasonable and fair, satisfies the requirements of fairness, failing which the matter can be referred after the fact, because employees have 90 days to refer a matter to the CCMA after the perpetuation of an unfair labour practice. But going back to that, employers must make sure that there's ample justification on their part for withholding benefits. In my view, there probably is ample justification during this period. As I mentioned last week, and just to reiterate again, the law seems to have now conflated remuneration and benefits. So an extended definition of remuneration would extend to, for instance, medical aid contributions and pension and provident fund benefits, and contributions on the part of the employer. And in that case, the unfair labour practice provisions would extend and cover those contributions as well as general benefits that fall under the generalized, for instance, a transport allowance or a food allowance that would ordinarily fall under an unfair labor practice provision. So my general sense is that this will not constitute an unfair labor practice. I believe that the COVID-19 full lockdown directive would excuse employers from making these contributions. I think it would further could be extrapolated to protect employers and give them justification for not paying bonuses. As much as I hesitate to say that, but I think long term there will be ample justification in light of the economic damage inflicted on companies that have had to lock down and close shop during this period. I think they will be able to, certainly with discretionary bonuses, I've no doubt in the case of discretionary bonuses, but I believe that this can also apply to annual bonuses, because there does seem to be rationality and reasonableness in the decision to withhold withhold bonuses, even if they are contractually included in employment contracts. As I say, a lot of this is speculation, it's untested, but this is my view from an interpretation of the law. Having said that, there have been some concessions made by the various sectoral bodies that deal with pensions, provident funds, and deal with medical schemes. Very briefly, looking at the slide, the Pension Funds Act requires employers to make payment of pension fund contributions, and the same extends to provident fund contributions within 7 days of the start of a month. And the Act is very clear in that an employer that fails to do so will be committing a criminal offence for non-payment, and can incur fines of up to 10 million rand and imprisonment of up to 10 years. So it's no laughing matter to withhold pension fund contributions. Notwithstanding that, the Financial Sector Conduct Authority, the FSCA, issued a communication shortly before lockdown to provide some kind of guidance to pension funds and provident funds on how to deal with financially distressed employers and employees who are unable to meet contribution requirements. And what they indicated is there is scope for suspension of contributions during this period. However, there has to be some provision in the rules of specific funds, of each individual fund, which makes allowance for breaks in payment, for instance, arising out of temporary absence from work, a break in service, a postponement of contribution payments, which would clearly apply in this case, and a reduction of pensionable service for those employees that are working reduced working hours. They have also indicated that funds that do not have these rules in place would have to urgently apply for such rules to be approved by the FSCA in order to facilitate and to legitimize the suspension of contributions over this period of time. So it seems that they have expressed or indicated empathy and a willingness to be flexible during this time, but the obligation is on pension funds themselves and provident fund themselves to implement these directives. They have also indicated that funds, and this is all pension and provident funds, should still try and keep what they call full risk benefit premiums going. That is for life, disability and funeral cover, obviously in light of the potential outcome of employees or members incurring facing ill health or death during this period. Right, as far as medical schemes go, this is even more, for me, even more concerning, because an employee or employer that does default on a medical aid contribution effectively breaks cover during that period of time. So again, this has been something that has been noted as an issue of concern by the Council for Medical Schemes, that published on the 26th of March, which is directly at the time of lockdown about to being implemented, a circular on lockdown measures. The directive is simply, and this is really it is a very short document, and I have put the quotation out of the document, in the spirit of social solidarity to investigate all disruptions to medical contributions on a case-by-case basis and determine the merits thereof prior to termination. So a very generalized directive to medical schemes, essentially urging them to give some kind of temporary reprieve to employees before terminating cover over this time. But as I'm saying in the slide, it remains wholly within the discretion of the specified medical scheme whether to grant these dispensations or not. And financially, this is obviously a concern for medical schemes themselves that will not be able to financially withstand all members not making payment at the same time. And there are similar concerns with regard to other benefits too, outside of the medical and pension contribution scenario. Housing allowances, car purchase agreements, one's hope is that there will be some kind of reprieve given or some kind of suspension of obligations, but it very much depends on the particular funds or authorities concerned in each and every place. We're going to do a quick poll now just to establish who does in fact face this concern with regard to benefits. The poll will just give all of us a sense of whether this concern will apply and whether to take what I've taken into consideration. The poll question is, if your employees are unable to work due to the lockdown and their remuneration package includes benefits, for example, pension, provident, medical, amongst others, have you continued to pay these contributions during this period? First answer is yes, second no, and the third option is I don't pay my employee benefits. Just a few seconds to allow everyone to enter their answers. Okay, just to give you some feedback on this, 63% of you that have completed the poll are continuing to pay benefits, which is very encouraging. 11% are not continuing to pay benefits, and 26% are not paying their employee benefits. But and it's very encouraging to see that 63% continue to do so. We obviously don't know the extent of the lockdown and whether it will continue to be extended. I certainly hope not, as do all of you. But the ability to continue to pay benefits will clearly depend on the extent and length of the lockdown. So thank you for answering that poll. I'd also like to put up a second poll question, which will relate to our slide that's coming up now with regard to annual leave. So if we could put up the second poll. The second poll is, if your employees are unable to work due to the lockdown, have you required them to take annual leave during this period? Just a few more seconds and I'll provide you with feedback on this. Right, so 37% of you have required employees to use their annual leave over this period, 52% have not, and 11% have indicated that their employees have been put on another form of leave. Perhaps when we get to the question and answer scenario, I'd be very interested to hear what other kinds of leave you have explored in those circumstances. But 37% have not required, 37% have required your employees to take annual leave. Right, thank you, Sarah, for that poll. I'll just move on to looking at leave provisions now. We could take that poll question down. Sarah, is that poll down?
Hi, Tammy. Yeah, everyone just has to move it themselves, I think.
Oh, okay.
Close it yourself, yeah.
I just need to get onto the next slide, and it's not going onto the next slide. Right, got it. Perfect. So as far as leave provisions go, You are quite within your right to have required employees to take annual leave during this period. The Basic Conditions of Employment Act, Section 20, subsection 1, requires, as a general rule, for annual leave to be taken in accordance with an agreement between the employer and employees. So under ordinary circumstances, there would be communication between employers and employees as to what would be the most suitable time for both parties, but specifically for the employer in terms of the employer prerogative as to what time or time of year annual leave would be taken, with the general emphasis being that employees would take their annual leave at different times unless there's a shutdown over the Christmas period. Where there is no agreement between the parties, then it is up to the employer themselves to determine a time that is suitable and applicable in this to take annual leave. And this would be a kind of situation that this applies to. The employer, there clearly is not going to be agreement between every employer and employee to take leave during this period, in which case the employer can impose that obligation on the employees to take annual leave. Bearing in mind, annual leave is simply 21 consecutive days, which is effectively 15 Monday to Friday working days. Not every employee has their full tranche of full amount of annual leave available, certainly the beginning of the year, which means that this annual leave for the entire year would be taken up by this lockdown period. Leave generally is, annual leave is on full pay, and this could pose a problem for an employer because they are then left with the same situation that they're continuing to pay all their employees on full pay during the lockdown period. But there has been a recent amendment. In actual fact, after I even drew up these slides, yesterday I was notified that on the 16th of April, there was a further amendment to the Temporary Employment Employer-Employee Relief Scheme, the TERS scheme, which also caters for the scenario where employees are put on forced annual leave during this period. This has apparently not been gazetted yet, even though they have been disseminated, these recent amendments. But what the amendments say, that if employees are put on annual leave, and that's paid annual leave, the employer will be able to claim reimbursement from the TERS scheme to offset the payment that they've made during this imposed annual leave. So to offset essentially the financial problems employers are going to face in paying a full workforce their annual leave over this period of time, paying them their full pay, they will be able to get some form of reimbursement through the UIF, through the TERS scheme. Clearly, the same application procedures will apply, and the same teething problems that I've mentioned to you at the beginning of the webinar are likely to apply, but the provision is in place. And what this will mean is that the employer will be able to get some form of reimbursement for the payments made during annual leave, and they'll be able to credit their employee their leave days back again. So this essentially is having the effect that employees will be able to still be paid by the employer, and the employer gaining some kind of reimbursement from the UIF for those annual leave payments. It's quite an unusual inclusion. I was quite puzzled when I saw that, but it is clearly to overcome the problem that I've mentioned, that there will be cash flow problems by companies that have to pay all their employees annual leave at the same time. I did mention in the last seminar that the UIF TERS scheme has also included sick leave due to precautionary or medically imposed quarantine over this period, that the TERS scheme will pay for employees that are in precautionary self-quarantine for a period of 14 days, purely based on a letter from the employer and not a medical practitioner's letter. And after the 14th day period, a medical certificate will also be required in addition to the employer's letter, but that would be covered in terms of UIF benefits over that period. The sick leave would be subject to credits, so how many credits an individual employee has clocked up at the UIF in terms of how long they've worked and how much they've contributed. And obviously it's also subject to the sliding scale, as mentioned, with the ordinary TERS benefits that are available, which range from 38 to 60%, but it is income. Perhaps I didn't make this clear last week, because those sick leave benefits also tie in with sick leave pay at a workplace. So if an employee is benefiting from claiming UIF benefits due to their sick leave period, it will also come off their sick leave entitlements at the employer. think I've covered most of that now. The only thing I did want to briefly mention is negative leave. Unpaid leave is essentially what all employees are on at the moment, to be perfectly honest. But negative leave, can an employer start spilling over into leave for the following year? And my sense is this cannot be done without agreement from employees. I think employees would have to, and I say I think because, as I said, a lot of this is speculation, but my sense is that the basic conditions provides for 21 days consecutive, 21 consecutive days annual leave in a leave cycle. It doesn't provide for negative leave, taking leave of the following year going forward. And without that, it's my belief to do so without consultation and without agreement from employees that this will in fact be in breach of the Basic Conditions of Employment Act. So this would have to be something that's discussed with employees and implemented. And I think employers would have to think very carefully about the health and the wellness considerations in terms of effectively removing employees' leave for the following year too. I think that it could have very negative effect on employees' wellness at the end of the day. Again, also mentioned this very briefly in our last seminar without going into it in any great detail, that in terms of the compensation fund, COVID-19 has been declared an occupational disease. In other words, employees that contract COVID-19 at the workplace will be entitled to compensation, full compensation from the compensation fund. The compensation is, as I mentioned last week, generous at 75% of that employee's salary, up to a threshold amount, but the threshold amount, the maximum salary that 75% would apply to is a sum of 400 and, let me just give you the exact amount, 484,000 Rand. So 75% of that would be payable. There is a formula for calculating a daily rate, and the compensation fund will pay up to 30 days for employees that are recuperating from having contracted COVID-19 at the workplace. It is categorized as a temporary total disablement. In other words, employees temporarily are totally disabled and unable to work during this period of time. From the application process point of view, the obligation, the onus is on the employer to report this illness to the compensation fund. There doesn't seem to be any kind of criminal or any type of liability in terms of fines or further from the compensation fund for a failure to refer it, but that I'm sure will come in time as further regulations come out. But at this point in time, the employer is required to report all compensation fund related occupational injuries or diseases, and this would clearly fall under that. The compensation fund will also pay for funeral expenses, and they will pay pensions to dependents, that's children, dependent children, and to a dependent spouse over that period and going forward for the full duration of the pensionable payout. So that will be the full duration of those pensioners, essentially, lifetime. So it is a generous payout. It's not necessarily the full salary in that situation. It is determined by a formula, but the compensation fund will pay for that. Now, the question that I didn't get a chance to discuss last week at all is what happens for employers that continue working, their operations continue, and this also applies to essential services that have lost a lot of business, but largely rarely applies to companies that have had to close their doors partly or entirely, is can they convert their employees to short time going forward? And I don't mean for the remainder of the lockdown period. What I mean is going forward for possibly years to come, or certainly for the years to come. Or can they simply notify employees that they are converting down to a shorter working day, reduced working hours due to their economic and financial challenges arising out of this COVID-19 lockdown and its economic consequences? The definition of short time in terms of the Unemployment Insurance Act refers to it as a temporary reduction in the number of ordinary hours of work owing to reasons including slackness of trade amongst others, and it's imposed in terms of the Unemployment Insurance Fund. it is regarded as a temporary measure for a temporary period where there's only a limited amount of work for an employee to do for their employer. But what's important to bear in mind is short time is an alternative to retrenchment. It's not a self-standing scenario or process. And there has to be a number of procedures and considerations implemented before short time can unilaterally be imposed. Either there has to be a contractual inclusion in an employee's employment contract that the employer is entitled to reduce the hours of work in terms of their discretion, imposed, exercised reasonably. Some employment contracts certainly hadn't anticipated the COVID scenario, but obviously anticipated seasonal variations or fluctuations, will include a provision to say that if the amount of work is reduced, then hours of work will be reduced. That is if it's included contractually. If it's not included contractually, there has to be agreement, there has to be consultation with the employees, or if there's a union in place, with the employee representatives to agree short-term provisions. If this is not agreed, then this will have to fall under a retrenchment procedure, and I'll talk about that in the next slide. But just to point out that the Unemployment Insurance Act itself makes provision for payment towards employees that are working short-term or have reduced working hours that are now not receiving their full remuneration during this time. It is not a particularly over-generous contribution on the part of the Unemployment Insurance Act, but it goes some way to topping up the reduced salary in those circumstances. And what the Act says, and I have put it here in this slide, that a contributor employed in any sector who loses his or her income due to reduced working time, despite still being employed, is entitled to benefits if the contributor's total income falls below the benefit level that they would have received if they'd become wholly unemployed, subject to them having enough credit. So in other words, if they are receiving less than they would have received in terms of the TERS benefit, that will effectively be topped up so that their salary could come closer to, together with the reduced working hours income, a supplementary salary to bring them closer to that benefit scale. This clearly works off UIF credits and doesn't apply directly to the scenario where the TERS scale that does not use benefits and credits at all. As far as retrenchments go, this is a legalistic process. Generally, lawyers are involved in retrenchment procedures, but for those that haven't had the opportunity to call lawyers in at this stage, this is just something to bear in mind, that in order to retrench, there has to be consultation and a joint problem-seeking approach. It's not something, again, that can be unilaterally imposed. The retrenchment procedure generally has to start in terms of the legislation with the issuing of a Section 189(3) notice, which sets out the reason for the retrenchments, the planned numbers and timing of the retrenchment, the severance pay considered, and also looks at possible alternatives to offset the necessity to retrench at all or retrench the numbers anticipated. Now, part and parcel of this retrenchment consultation process is to also listen to suggestions and alternatives proposed by the affected employees, and particularly where the unions are involved, there might be alternatives suggested. And part and parcel of that would also look at reduced working time scenarios. We'll look at formulas for perhaps profit-based payment formulas. And I've heard a lot of talk in the industry where companies are looking at, instead of paying full salary, they will pay a baseline salary, and depending on company profits, a percentage criteria or a commission, but a calculation of remuneration based on increased profits. So essentially incrementally increased. For those employers that are large-scale employers, in other words, large-scale retrenchment scenarios that employ more than 50 employees, and for instance, if they employ between 50 and 200 employees, if they intend retrenching up to 10 employees, they will fall under Section 189 capital A, which implements a 60-day consultation period utilizing a facilitator at the CCMA. So it's not something that can be quickly passed through and implemented. There is a waiting time period. There is a consultation period with a CCMA facilitator, and it's not going to be a quick and easy fix for employers that are facing ongoing financial problems and challenges. Another alternative outside of the retrenchment route is to simply try and renegotiate terms and conditions with employees. However, there is a provision in the Labour Relations Act is regarded as an automatically unfair dismissal. In other words, an employee that establishes that they have been subjected to an automatically unfair dismissal on this ground is entitled up to 24 months, 2 years compensation for breach of this provision. And that provision prevents or prohibits the dismissal of employees to compel them to change, to accept change terms and conditions. So I'll give you an example. If an employer calls in a group of employees and says, times are bad, you need to accept reduced salaries, failing which you will be dismissed. That is a stock standard example of falling under section 187(1)(c) and will be regarded as automatically unfair dismissal. The employer needs to be very careful to not frame it in that way, but simply to say we are interrogating, we are looking at alternatives. Let's look at perhaps renegotiating terms and conditions, and then as a separate consideration down the line, if that doesn't work, we will now enter into retrenchments consultations, not to punish the employee or to compel them to accept new terms and conditions, but purely because financial factors prohibit the ongoing running of the company in its ordinary operations, financial operations. Very briefly, and I see the time is flying by, as far as essential service employees, I'm sure you're all very familiar who are essential services due to our lack of ability to access many services that we are ordinarily entitled to, including now cooked chicken from Woolworths, much to my horror. But the full list of essential services employees are on the government site, and I have just listed some of them as financial, insurance, groceries, electricity, pharmacy, municipal services, health, etc., which I'm sure you all are aware of. But a question again that I've had posed to me on many occasions is some of those essential service employees have expressed grave reservations about working, about potentially infecting their family and vulnerable members of their community, and have simply refused to go to work. What are the consequences of that? Sadly, for those employees, it will be regarded as insubordination. In actual fact, it will be regarded as gross insubordination, which will be a dismissible offence. And disciplinary inquiry would have to be convened. It would not be simply a summary dismissal scenario. There would have to be a disciplinary inquiry, but this is a refusal to obey a lawful instruction. And lawful, the emphasis being on the word lawful, it constitutes insubordination, and there are grave consequences due to that refusal. Another question that's been posed is, what about support staff? For example, at a hospital, what about the reception? What about the cleaners? What about the staff in the kitchen? They're not essential service employees in the true sense of the word, but are they now compelled to continue working? The admin department, are they obliged to continue working during this lockdown period? And again, the law is very clear. Yes, they are. They are support staff to essential services, and without their support, the essential services will face unsurmountable obstacles. So they too, for the purposes of this scenario, the COVID-19 scenario, they too would be obliged to continue rendering their services over that time. From the employer's side, obviously they need to do whatever they can to ensure the safety, health and safety of their employees. And we are all aware that that is to provide protective equipment, personal protective equipment during this period. And a final question that's been asked to me is the employer obliged to provide transport? As we know, these essential service employees have to get to work. Taxis are only able to run at 50% capacity, and I believe that isn't in fact happening. And is the onus then on the employer to provide transport? And yes, the employer needs to make sure that their employees can get to work. For those that do not have transport options in the areas that they live, the onus is on the employee then to provide private transport, whether it is to arrange for minibuses or taxis, or I've even heard some employers are arranging Uber services for their employees, but the onus is on them where employers employees are facing insurmountable obstacles or obstacles, not even insurmountable, in getting to work. And my final slide is just in terms of the Occupational Health and Safety Act. Now, every employer is obliged to comply with occupational health and safety considerations in terms of the Act. And what the Act says, Section 8, that every employer is obliged to provide and maintain, as far as reasonably practicable, a working environment that is safe and without risk to the health of its employees. And this includes a whole lot of factors. I've just summarized some of them, but that is to take steps to eliminate or mitigate any hazard or potential hazard before resorting to personal protective equipment. And in this situation, I think there is quick resort to personal protective equipment. This is the generalized duties, providing information, instructions, training and supervision to ensure the health and safety of employees at work, and enforcing such measures as may be necessary in the interest of health and safety. These are very generic duties, but in the COVID-19 scenario, I'm sure that you can imagine which ones apply to your particular workplace or particular businesses. This provisions also apply to other persons outside of the employer-employee relationship that are entering a workplace. So if you have a client, a supplier, a delivery courier person, those same duties apply, and the employers that fail to implement these health and safety requirements will be in breach of the Act if they do not take further steps to obviously protect the health and safety of their own employees, but all persons entering the workplace premises. The provisions, the regulations, the general safety regulations published under the OHSA allow employers and business owners to prevent any person from entering a workplace where there are concerns around health and safety. This also includes the entitlement to require persons entering to undergo temperature tests, any kind of medical evaluation, but it must be borne in mind that medical testing is governed by the Employment Equity Act, and there has to be consent for medical testing in any situation at a workplace. So any employee that's required to undergo any kind of medical testing, including even a temperature test, has to do so with their full agreement. Let's go on to the last slide, which is the Contact Us slide. Just as a matter of interest, the last poll question I wanted to put up, just to look at possibilities around retrenchment. If we could just put that final slide up before we go on. Is it a possibility that your business will have to retrench employees due to the economic impact of the lockdown? Is this something that you will have to think about long term? The answers are either yes, no, or that you're looking at other short-term or alternative options in this situation. Just a couple more seconds. Right, it looks like 26% will have to possibly, and I did frame it as possibly, retrench employees during this as a result of the economic impact of lockdown. 29%, lucky ones, no, and 46% are looking at short-term and alternative options. So there's quite a wide range of responses, but certainly for those 25%, it's not something that's going to be an overnight process, and thought processes will have to be initiated and procedures commenced relatively soon if this is a possibility. Right, thank you for that poll. Let me take that off the screen. What is up on the screen is the extended learning contact details for those of you that would like to contact UEL for any further training. Sarah, should I go on to the questions now, or is there anything that you want to say at this stage?
No, you can go on to the question and answers, Tammy.
Okay, perfect. I'll get to the last slide with upcoming seminars shortly. Right, you do have an opportunity, and I see some eager people have already got their questions in. Thank you very much for that. You will have an opportunity to type up questions and I'll just answer them live, not type them back. The first question, thank you, from Ravesh, is if we have to credit annual leave, and also noting that the UIF does not pay 100%, taking into consideration that annual leave has already been paid, then the employer will not get the full amount back for annual leave. This is correct. My understanding, and this is, as I said, a last minute amendment, they seem to be coming out furiously. My understanding is that if you've paid full annual leave, you will only be able to get a reimbursement for a portion of that. I did talk about the TERS benefits last week, but the maximum amount of reimbursement per month will be 6,700 Rand per month. The balance would continue to be taken off for annual leave, and one would have to work out in terms of days how many days credit would apply as almost reimbursement to those employees, but you certainly won't get the full amount back. So yes, I hope that answers your question. Amanda's question, that if salaries remain unpaid 7 days after they fall due, is interest still payable for pre-lockdown, during the lockdown and post-lockdown, and what is the rate? Well, no, Amanda. If salaries are unpaid, and they're unpaid because a company has locked down entirely, they haven't been able to work at all, the obligation to pay salaries and clearly interest on those salaries does not exist at all. If companies have partially closed down, the obligation is to pay partial salaries, and if that is not paid, and that was paid 7 days later, I would imagine that interest would be payable. I also would imagine that that will be government-based interest, and obviously that is fluctuating all the time, but I'm not sure the rate does fluctuate all the time, but certainly if the salary owed is for partial payment or partly working, yes, interest would accrue on that. But just bearing in mind the no work, no pay principle, that salaries do not have to be paid in these circumstances. The next question from Avinash is, domestic workers who do not have UIF, is the employer entitled to pay a full salary? And if employers pay 50%, is this sufficient and cover employer legally? Again, the same rules apply. And I hesitate to say this because it is an extremely, extremely sad situation for domestic workers, the bulk of which are at home not earning any salary at all. If domestic workers are not registered with UIF, the employer's payment of their salary, whether it's full or 50%, would effectively be a gratuitous salary. If they are working, they would clearly have to continue to be paid their full salary, and a failure to pay if they are working would be in breach of the Basic Conditions of Employment Act. But failing that, 50% payment is gratuitous at the end of the day because the no work, no pay maximum applies. Okay, that question's done. Are there any other questions before we wind up? No, there doesn't seem to be any other questions. If we could close the question and answer session, I could try and get to the last slide, which indicates our forthcoming seminars. Give it a second and see if I can get onto that slide.
In the meantime, I will launch the last poll where you can rate the session.
Perfect.
So it should come up on your screen now. So how would you rate the session today? Very good, good, average, fair, not satisfactory. Obviously, these are very limited in terms of responses, but when we do send out the link to the video, there is an opportunity where you can possibly give more in detail feedback. You can also maybe offer some suggestions for upcoming webinars. So yeah, you can take that opportunity. We'll just give you a few seconds to fill out this question. And I don't know if Tammy, you can get that slide on or not.
I don't know why it's not coming up, but if it doesn't come up, perhaps Sarah, you could just indicate what are the dates for the forthcoming webinars. I'm not sure why my screen seems to have frozen. Okay, well, in terms of our feedback, thank you very much. We've got gold stars, Sarah and I. Thank you so much for your positive feedback, and hope to see you again at our forthcoming webinar. I still haven't managed to...
That's fine. I'll just mention a few of the upcoming ones, and otherwise they can always contact us by our website, and we'll also add a few in the mailer that we send out.
Perfect.
Okay.
Through the
Yeah.
day.
So thank you, Tammy, for your presentation today. I'm sure you provided a lot more clarity to business owners, and hopefully that they can go ahead and know a lot of the legal terms and legal way going forward. Yeah, so thank you for coming today, and we look forward to your upcoming webinars. So as I did mention previously, the video and the slides will be available on our website, and we'll also be sending out the direct link to all of you who have attended once it is ready. Yeah, so thank you as well to all our attendees for joining us, and also do take note of the upcoming webinars. This Thursday, on the 23rd of April, we do have how to grow your business from an employee to entrepreneur. And then Tammy will be with us in 2 weeks' time on the 5th of May. And it will also be a COVID-19 talk, except this time she will focus on labor law for individuals. So we also have a few online courses that we're offering for free during the lockdown. So we're sharing some of our own courses, as well as partnering with other organizations in order to provide free access. So do visit our website, www.ukznextendedlearning.com, to see what we have on offer. If you just scroll to either the free courses or online courses tab, that's where you'll access all of these. Otherwise, hope you enjoyed the session. Stay safe, and we'll see you next time.
All the best. Thank you, Sarah.
Okay, bye.